Talk and Gavel is for educational purposes only. While Chris and Jamie always try to provide accurate information, the law is like what I'm willing to eat. It's always changing. This podcast is not legal advice and does not create an attorney-client relationship, but they promised me it would be a lot of fun. For you. Can I get my candy now?
So the kids are alright. So the kids are alright.
Hello, everyone, and welcome to Chalk and Gavel, where we explore how the law shapes education one case at a time. I'm Chris Thomas.
And I'm Jamie Cudlitz. Welcome back, everybody. As we promised you in one of our earlier episodes, we are going to cover a case today called the Parents Defending Education versus Olentangy Local School District Board of Education. And this is a case about a school board policy that forbids the intentional misgendering of students. So sit back, relax, and we'll dig right into this one.
Fun fact, this is where I student taught.
Oh, hometown case.
Absolutely. So it's my turn to do a hometown case. You got all those North Carolina cases.
All right, this one's for you, Chris.
So the kids are alright. So the kids are alright.
All right. Well, let's dig into a bell ringer. So this bell ringer also comes from, I guess, my current home state of Florida. So this involves a teacher, A.V. Very, who was let go by the Florida Virtual School after they used a gender-neutral pronoun in their kind of course materials. So the teacher, A.V. Very, used the honorific MX, mix, in their school materials. So they identify as non-binary. They had identified as female before making the transition, and the school took issue with them using the honorific mix.
So instead of Mr. or Miss or Mrs. Or Doctor or whatever, they decided to use MX.
Yep, use MX because, according to them, it was gender neutral and it aligned with kind of how they experience their gender identity.
Okay.
And so the school said essentially that this practice by this teacher violated a recent Florida law that prohibits school employees from providing to students their preferred personal titles or pronouns if those personal titles or pronouns do not correspond to the teacher's sex. And so Florida's been in the news a lot recently with laws like this. You know, there was a law a couple years ago that critics called the Don't Say Gay bill that dealt with teaching content related to sexual orientation and gender identity. What's really interesting, though, to me is, so if McVeary was let go for using this gender neutral term because of how they self-identify, that seems to me to kind of run afoul of some federal law. So we've got this really interesting kind of conflict here between state law and federal law. So we've got this Florida law says you can't provide your pronouns if they differ from your sex. But federal law, you know, we recently had a Supreme Court case, Bostock versus Clayton County, which said under Title VII that deals with employment discrimination, that discrimination based on sexual orientation or transgender identity was discrimination based on sex that's prohibited by Title VII.
Right. That was a big Supreme Court case. Yeah.
Oh, yeah, huge. And it actually surprised a lot of people because I think it was a 6-3 decision with some of the more conservative justices joining the liberal justices to prohibit transgender and gender identity discrimination. So this teacher, McVeary, has already filed a EEOC complaint. So EEOC is the Equal Employment Opportunity Commission at the federal level. So they're responsible for enforcing these employment civil rights laws at the federal level. So we'll see where that goes. But, you know, Florida Virtual School is kind of caught between a rock and a hard place here where they've got state law versus federal law. So we'll see how that plays out. You know, I feel for this teacher just because they're going through this and are having to kind of file this suit or bring this complaint.
Yeah.
In some of the reporting that I've seen, they're kind of acknowledging that this is going to be challenging to bring this suit. It'll be interesting to see how it all plays out.
Yeah, and this is a pretty recent. This is end of October. This teacher was let go.
Yeah. And I'll end with this thought. So, all of this is kind of stemming from an environment in Florida politics where Governor Ron DeSantis has been kind of saying that he wants to kind of remove gender politics from schools. And this quote from Very, I think, is really telling. They said when they were, made the decision to use this honorific, they said, "I didn't ever say, hey, I'm non-binary. We had physics to do." And I think that that's just a really good encapsulation of what's happening in schools.
Yeah. Well, it'll be interesting to see how this one plays out, because I think there are very similar issues happening all across the country. This is definitely what you would consider one of these hot topics, and aligned with the case that we're going to cover today, the Olentangy case.
Mm-hmm. So one last comment. So this is definitely a test case, as a lot of these recent laws that were passed around these issues are starting to get litigated. So, this might be one of the first ones. So we'll have to see how it turns out.
Yep. We'll be paying close attention.
Which I think is a perfect transition to a case that actually has been litigated, this Parents Defending Education case versus Olentangy, where we've got a court decision dealing with kind of a challenge to a policy that forbids students from intentionally misgendering their classmates. So let's dig into it.
Yeah. So as Chris said, we've got this case that is coming out of Ohio. Chris, that's your old stomping grounds, right?
It is, yeah. Lived in Ohio most of my life.
And you did your student teaching in Olentangy School District, right?
I did, yeah. Back in 2011, I want to say. 12?
Oh,
I don't know. It was a long time ago.
So young.
It seems like a long time ago.
So this is an interesting case. It's very recent. It was ruled in July of 2023. It is currently on appeal to the Sixth Circuit, which is where Ohio is.
Mm-hmm.
So it's not necessarily said and done at this point, but the ruling from the district court in the Southern District of Ohio is very interesting.
Mm-hmm.
So a few weeks ago, in one of our bell ringers, we were talking about a case, the Linmar case. Right, Chris?
Mm-hmm.
That was a case that had to do with transgender students' pronouns and whether or not the district could compel students to use people's preferred pronouns, correct?
Yeah, so the Linmar case dealt with that squishy language about, so the policy just said something along the lines of it required people to respect other folks' gender identity.
Yeah.
And the court struck it down as being, unconstitutionally vague under the First Amendment.
Yeah.
So, this is kind of a companion case to that. This one obviously comes out the other way. The court upholds the policy, at least at this stage. But it is interesting to kind of, not a lot of courts have addressed this yet.
Right. And so these, we spoke briefly about it a few episodes ago in that bell ringer, that Linmar bell ringer. So again, that was a case that went against the school district, and the school district lost. And this case that we're going to talk about today, Parents Defending Education versus Olentangy Local School District, went the other way, and the school board won this particular case. And it goes to show, like we said earlier, that very small differences in policy language could have a very big legal impact, because both of those cases deal with pretty much the same issue, but the policy was written very differently.
Right.
So let's talk about the facts of this case. It's pretty cut and dry. So we've got a school board that has a handful of policies. Now, the Olentangy School District is right outside of Columbus, so it's in a pretty big metropolitan area.
Yep.
It's the fourth largest school district in Ohio. It operates 16 elementary schools, 5 middle schools, and 4 high schools. So it's pretty big. And so the board has several policies that have to do with harassment, bullying, the use of personal communication devices, cell phones, and things like that, that are intended to maintain an education and work environment that is free from all forms of unlawful harassment. All right. So there's 3 specific policies that are referenced in this suit. The first policy is this anti-harassment policy that's been in place, modified recently, but it's been in place since 2011, and it prohibits harassment based on race, color, national origin, sex, which includes sexual orientation and gender identity, disability, age, religion, ancestry, or genetic information, anything that's sort of protected by federal civil rights law. So that's one policy. You've got another policy that has to do mostly with how students use their cell phones and other personal communication devices, laptops, tablets, things like that, on and off campus, which is interesting in light of the last case we discussed, the Brandy Levy case.
Mm-hmm. Yeah, I wonder if they've updated their policies since Mahanoy.
Well, reading their policy, that particular policy, it says students are prohibited from using a personal communication device in any way that might reasonably create in the mind of another person an impression of being threatened, humiliated, harassed, embarrassed, or intimidated, which I don't really think the court weighed in on necessarily in the Brandy Levy case, or at least in the Brandy Levy case, it wasn't about that kind of speech.
Right. And that was kind of one of the green lights that the Supreme Court got for when schools might be able to get involved is when the off-campus speech is targeted at specific members of the school community.
And it's threatening.
Exactly. Yeah. So that seems to be a defensible policy right now.
For the most part, because it goes on to say, in particular, students are prohibited from using personal communication devices to transmit material that is threatening, obscene, disruptive, or sexually explicit.
Ooh.
So the obscene thing is potentially problematic in light of the Brandy Levy decision.
Right. Yeah. Because apparently flipping the bird and saying F school is totally cool.
Yeah. Or some people would consider that obscene.
I know it when I see it.
Right. Exactly. So that was the second policy, was the communication devices policy. And then the third one was this code of conduct. So the code of conduct includes a section on hazing, harassment, intimidation, bullying, and sexual harassment. And it defined harassment, intimidation, and bullying as any intentional, written, verbal, electronic, or physical act that a student has exhibited towards another particular student or students more than once, and the behavior causes mental or physical harm to the other student and is sufficiently severe, persistent, or pervasive. All of this is language that is used. Mm-hmm. It's very common definitions of bullying and harassment, right?
Sure. Yeah, and you can see what all these policies are trying to do.
Right.
They're all kind of aimed at like making sure that everyone feels safe, feels respected, that no one...
Well, be careful with the respect word.
well, don't put that in the policy, right? Like,
yeah, exactly.
But yeah, you can still pursue it as a goal.
Yes, the spirit of the policy.
Right.
Anyway, so those are the three policies.
So what's interesting about some of these policies is the ones that are school board policies are kind of standard policies from this group called Neola. So Neola is an organization that prepares draft school board policies and then provides them to school districts who then revise them, adopt them to their local context or to their local needs. And then they get passed by the school board and become the board policies. So in Ohio, Neola, according to their website, has like 1,500 school district clients across 6 states. A lot of schools in Ohio use these policies. So if this policy is something that Olentangy has, it's a good bet that a lot of other school districts who also use Neola's services also have policies that are very similar to this. But that's one thing to keep in mind, is that how this policy goes could affect a lot of different districts who have very similar, if not identical, policies.
That's interesting. And I guess when you're talking about a company like this, whose job it is to put out these policies for consumption, you would think that they are getting vetted over and over and over again by, a lot of lawyers, right?
A lot of lawyers, not only at Neola, but every school who, before they adopt these policies, their lawyers typically go over them as well. So they lots and lots of people are looking at these policies to make sure they're as good or as defensible as they can be.
Yeah. So, one of the other things that is interesting about the first policy referenced in this suit, the anti-harassment policy, was that it defines harassment as any threatening, insulting, or dehumanizing gesture, anything that places a student or school employee in reasonable fear of harm to his or her person or damage to his or her property, has the effect of substantially interfering with a student's educational performance, opportunities, or benefits, and so on. It also talks about anything that is severe or pervasive enough to create an intimidating, hostile, or offensive educational or work environment, cause discomfort or humiliation, or reasonably interfere with the individual's school or work performance or participation. So one of the big takeaways in this case, which is what led to Parents Defending Education bringing this suit against the district, was the fact that these policies mention the intentionally misgendering of transgender students as being something that is prohibited. Okay, so what happened in February of 2023, a parent emailed the school district raising a concern that their child could be disciplined for violating these policies if they referred to a fellow student using pronouns different from what the student prefers. So the parent asked in the email, if my devoutly Christian child who believes in two biological genders, male and female, and that those genders are decided at conception by God, would they be forced to use the pronouns that a transgender child identifies with or be subject to reprimand from the district if they refuse to do so? And the parent was told by the school district's legal counsel.
Which is smart to get legal counsel involved in this because you can kind of smell a lawsuit, right? Like they're asking some very pointed questions.
Totally. It was, yes, very smart to just, rather than have a school official potentially respond, I don't want to necessarily say emotionally, but this is, like you said, smart to get a lawyer involved to craft a very carefully constructed response to this potential complaint, or at least, or the question that this parent raised. So the council's response was, quote, while the children certainly may maintain religious rights of freedom at school, those rights do not relieve them of the obligation to comply with school policies. As such, a student purposefully referring to another student by using gendered language they know is contrary to the other student's identity would be an example of discrimination under board policy. So then the parent tried to get further clarification about the scope of those policies, asking if their child would be disciplined for expressing religious beliefs that marriage is between a man or a woman, or that homosexuality is a sin. The school district noted that students would not be disciplined for their religious beliefs. So, with respect to the parent's first question about pronouns, a student would be permitted to seek accommodations and avoid using pronouns where doing so would be contrary to their religious beliefs. So, in other words, the school district came back and said that if a student did not want to address another student by their preferred pronouns because of religious objections, they could seek accommodations that would permit them to avoid using pronouns that the student might want, right?
Right. Yeah. And you can see how complicated this situation is and all of the different considerations that are going on as this school is trying to navigate this really difficult balance between religious freedoms, First Amendment, parental rights, the rights of LGBTQ students to be free from harassment and discrimination.
Yeah.
All of these things are kind of like, getting thrown into the hopper and just kind of seeing what comes out. It's a really tricky situation to navigate for the school, which again is kind of why at least elevating this and getting some advice from your legal counsel is a great idea. And I love that this is another case that kind of starts with some emails, right? So going back to our very first episode with the Peltier case, that started with an email saying like, hey, is my child allowed to wear pants? And didn't get the response they wanted. That one ended up, that email got the school in trouble, right? Because they used kind of gender stereotypes to defend the policy.
Yeah.
Here we've got this very well-crafted response, which leads me to some of my favorite legal wisdom that I impart to my students when I teach school law. Dance like no one's watching. Email like it's going to be read in court. Because as here, it was.
Do you have any sayings about dancing in court?
It's never come up.
Yeah, so this is sort of what led to the lawsuit. And like we said, the district was trying to thread a very difficult needle. This is a very complex set of circumstances trying to protect students from harassment and bullying and those kinds of things, also trying to respect students' First Amendment speech rights, religious freedom rights, things like that. It's a very difficult balance that the school was trying to navigate, such that they even turned around and they said, listen, we can try to provide you with some accommodations so that you don't have to do this. Plus, they had language in their policy that specifically referenced the intentionality of the language or of the acts.
Right.
So, in other words, the policy doesn't say you could potentially be disciplined if you just make a mistake and you call somebody a pronoun by accident. Like, this policy pretty clearly references intentional acts as opposed to mistakes or things like that, right?
Right. Yeah, it's very limited in that way because it's only focused on intentional acts. So not this kind of inadvertent or even just having conversations about like, hey, what pronouns do you prefer? How do you self-identify? All of that's totally fine. That's something that comes up in the lawsuit. How sweeping is this policy?
Yeah.
How much speech does it capture? And the court takes a pretty narrow view of what the policy actually prohibits, which I think is what the school did too. So the school's interpretation of this policy is very narrow to what circumstances it applies to.
So tell us a little bit about how the courts responded to this.
Absolutely. So parent gets these emails, gets involved with this organization, Parents Defending Education, and the organization, along with the parent members, file suit against Olentangy in the Southern District of Ohio. So we are in federal court because they're making constitutional claims based on the First and 14th Amendment to the U.S. Constitution. So First Amendment, they've got a couple different theories for why the pronoun policy violates the First Amendment. First, they argue that it violates students' free speech rights, essentially that you are prohibiting me from saying what I want to say. Second, they say that this is unconstitutionally compelling speech by basically requiring students to say something that they might not agree with or believe in. So this idea that because they have these sincere religious beliefs, if the state requires them to use pronouns that their transgender student peers prefer, that's going to violate their beliefs because, they have these beliefs about the immutable characteristic of sex. And then last but not least, they argue that these could be also impermissible viewpoint or content discriminatory, meaning that they allow you to kind of be pro-LGBTQ, but they don't allow you to be critical of LGBTQ identities and things like that. So basically, the school is picking sides in this policy debate. And I said that was the last but not least, but there's actually one more, and that is overbroad. So these are overbroad, meaning that like they just capture too much speech and the policy isn't tailored enough to survive constitutional scrutiny. So lots of reasons potentially why the parents think this violates the First Amendment. Parents also bring a 14th Amendment claim here. And this is something that we'll talk about a lot, which is kind of this parental right to direct the care, upbringing, and education of their child. So under the 14th Amendment, parents have this right, but courts have been kind of hesitant to extend that into the school domain, where they've kind of said, maybe you don't have a fundamental right to direct the operations of the school, but outside of school, parents do have this fundamental right. So we've got these First Amendment issues, and then we've got these 14th Amendment issues. The court ultimately, at this stage, says, you know what? I don't think you have a likelihood of success on any of these claims. Therefore, the policy is going to stand. So this decision stems from a motion for a preliminary injunction from the parents and the parent organization. So essentially, they're asking the court in a very timely manner to stop enforcement of the policy while the case can go through.
Oh, okay.
And so at this stage, all they need to show, they don't need to show that they are ultimately going to win. They just need to show, the parents need to show that they have a substantial likelihood of success on the merits. Because if they've got a substantial likelihood, then the court's going to pause the policy. And that way they don't, continue the potential unconstitutional action.
Okay.
So, this isn't a completely on the merits decision, yes or no, but it does kind of show the court's thinking about these issues.
Yeah. So basically it's just is there enough for us to move forward? And if the court says yes, then they're just going to put the policy on hold until they figure out the merits of the policy and whether or not that violates the Constitution. So it's almost like, let's just take a quick first glance at this.
Right. It's the initial smell test. Sorry, that actually makes it sound more trivial than it is. It's a really big deal, right? Because depending on how this goes out, like the parties might settle. So if the school loses the preliminary injunction, the school has an incentive not to go to trial because they don't want to drag this thing out to the point where they think they might lose in the future. So it does have like substantial implications.
But wouldn't the parents feel the same way as well? Like, hey, the courts might not go in our favor, so let's try to work something out so we don't lose later on.
Potentially, for sure. Kind of depends on, what the political agenda here is, perhaps, and like what their ultimate kind of goal is. But whoever wins the PI is in a very good, let's call it a bargaining position as you try to get this thing resolved.
Okay.
If it's possible to get this resolved.
Yeah.
So court is hearing this preliminary injunction and denies the injunction. So refuses to enjoin the policy. The policy is still in effect, even as this is being appealed to the Sixth Circuit, which is the federal circuit above the Southern District of Ohio. So digging into their claims, First Amendment claim, the court looks at this, and we talked about it last week, but they start with Tinker, and they apply the balancing act of Tinker, where essentially you have to balance students' speech rights against kind of the needs of the school in maintaining a orderly environment and in protecting the rights of other students. And to the court, this was kind of a close call, but kind of a simple conclusion where this policy or these policies fall squarely within that second part of Tinker, where you can prohibit student speech that invades the rights of others. And basically the court holds that because the school has kind of forecasted that misgendering students can have these really profound effects on transgender students, the court digs into a lot of the social science and kind of the consequences that transgender students face in schools. And looking at all of those, the court said, like, if we allow this to happen, then there's a really good likelihood that you're going to invade the rights of these children. You're going to make it so that they're unable to kind of pursue their educational opportunities in the same way. There's going to be all of these hosts of negative consequences to these kids.
Right.
So the students themselves can't make a First Amendment claim here because they can't succeed on a First Amendment claim because of that second prong of Tinker.
Got it. Interesting.
And I think that all makes sense. Like we're trying to balance the interests here, right? Like there's a right to free speech, but on the other hand, you also have to balance the kind of well-being and dignity of the other students. And this court at least erred on prioritizing equal dignity.
The second piece of it. Right.
Yeah.
So right now it's on appeal to the Sixth Circuit.
Mm-hmm.
How do you think it's going to play out?
Oh, I'm not going to go there. No. So the thing about courts of appeals is these get assigned to 3-judge panels.
Okay.
And, I haven't looked to see what the panel of judges are for this case. It's not like the Supreme Court where we know exactly which 9 justices are going to hear the case.
Right.
So the court has this really interesting distinction that it draws for how to understand these policies and the speech that they prohibit. So it kind of draws a distinction between the use of pronouns differing from those preferred by transgender students and speech that questions the prevalence of gender dysphoria or that discusses issues of gender identity. And this gets to those concerns about it being overbroad or being viewpoint discriminatory.
Okay.
Essentially, what the court is saying here is that these policies don't prohibit the discussion of these issues at all. All they prohibit is folks intentionally misgendering their peers or other students because of this really, to the court, this kind of like core issue that who we are and how we self-identify is really kind of the utmost importance. And so the policy for the court, it allows this bigger policy discussion about LGBTQ issues, but the balance they strike does a good job of kind of respecting individuals within those larger political discussions. So it's the difference between being able to target specific individuals and have an effect on those specific individuals versus having these larger conversations, which is completely protected by the First Amendment. Here, though, the court says that, the intentional misgendering of students, that's essentially verbal bullying.
Yeah. It's different than having a conversation about the topic.
Right. Yeah. And it's not necessarily expressive of ideology, right? Like, because we use pronouns all the time and we don't usually mean anything by them.
Yeah.
They're not necessarily kind of like meaning laden. They're just kind of an accident of language.
Okay.
And so all of that kind of goes into the court's decisions to kind of say that if you intentionally misgender somebody, that just, that's different.
It falls into that category of harassment.
Right. Yeah. So the next thing that the court deals with is this issue of compelled speech. So under the First Amendment, it's unconstitutional for the state to essentially force you to say something you disagree with. And that makes a lot of sense, right? Because we don't want the state or the government to be involved in telling us what to believe or telling us that we have to basically espouse belief in certain things.
Yeah.
So this all comes from a 1943 case, West Virginia v. Barnett, where the Supreme Court said that students couldn't be forced to salute the flag because doing so would kind of violate their speech rights to kind of say what they believe.
Yeah.
And so there's this compelled speech issue here. And, the school here essentially concedes that the policy effectively requires students to use the preferred pronouns of other students. And, I know the school kind of conceded that, so the court had to kind of agree with that. But I don't know if this policy really compels speech because it prohibits the use of pronouns that don't align with an individual's gender identity. Prohibiting something is not the same thing as requiring its alternative,
It's almost like if you don't have anything nice to say, don't say anything at all, right?
Right. Yeah, exactly. Yeah. Just because you're prohibited from saying something doesn't mean you have to say the opposite. You could just
not say
use first names. You could just, you just don't use pronouns at all. Or you just don't talk to the students that, you might not see eye to eye with.
And didn't the school board the attorney also said you could seek accommodations that would allow you to avoid using pronouns if that went against your religious beliefs? So,
right.
Like that's another way the school board said we are not compelling speech.
Right. Yeah. Yeah. There's an alternative here, right?
Okay.
But so the court, kind of assumes that it compels speech. And that's what courts do all the time. They'll make assumptions so that they can get to other parts of the argument.
Okay.
So they assume it compels speech, but they still find that it's fine under the First Amendment because it's not requiring you to really espouse an idea.
Okay.
Because the policy still allows you to essentially have disclaimers.
Yeah.
Like,
I don't agree with this. Yeah.
Yes, I don't agree with this. I think gender is a immutable trait.
Right.
But out of respect for my classmates and for the policy, and because I don't want to get in trouble, I'm going to use the pronouns that you prefer. And so because of that, and because using pronouns isn't really that, again, it's not necessarily this like value-laden expressive activity. It's more just kind of a formality of language.
Yep.
The court says that, there's not really concerns here about compelled speech.
Interesting.
Yeah. And then the last thing with the First Amendment is they argue that it is content or viewpoint discriminatory. And this one, the court kind of says, no, it's not really. Sure, it's content discrimination because it only deals with speech that is bullying or harassing, but schools have a lot of flexibility to kind of engage in that kind of control or censorship because they're schools, right? Like we have to protect their educational mission. They have to be able to create and maintain this conducive educational environment. And we also allow schools to do content discrimination because they've got to decide what to teach and how to teach it.
Yeah.
If we let students say whatever they want, whenever they want, the animals might run the zoo.
Yeah, exactly. Interesting.
Yeah. So then with the viewpoint discrimination, it's a little different. The court says that it doesn't prohibit you from saying any viewpoint. In fact, it prohibits someone from misgendering a transgender student in the same way that it prevents someone from misgendering a cisgender student. So, you can't misgender anyone under this policy. So it doesn't viewpoint discriminate because
it applies to everybody.
It catches people on both sides.
Yeah.
Exactly. And so because of that, the policy survives all of the First Amendment challenges, including the overbroad challenge, which, unlike the policy in Linmar, this one is very specific and does not go very broad, right? Like just these very specific acts that it prohibits.
Wow.
It doesn't go too broad.
Yeah, that's really cool. I mean, that's fascinating. It's going to be really interesting to see where this case goes.
Mm-hmm.
So we will obviously report back on that when the time comes. If the time comes. I mean, something will happen with it. They'll either settle or it'll go to court. And whatever happens, we'll tell you what happens there. Okay. Anything else on that one, Chris?
No, just, we'll see what happens. I think this one's going all the way.
Yeah.
Well, no, let me rephrase that. I think this one will go the distance. We'll see how far that goes. I don't know if this is one that the Supreme Court will take up, but
it's not the last we're hearing of this case.
No, absolutely not. This one is going to bounce around because the same thing happened when we were having cases about restroom access for transgender students. Right. One of the big cases, Grimm versus Gloucester. I hope I said that right.
I think it's Gloucester.
Dang it.
I think. That was also was a Fourth Circuit case. Yeah.
Yeah. And that one took years
Right.
to go through the system.
Right.
It bounced up and down a couple times, went to the Supreme Court, came back down after some administrative changes, things like that. So I think we could see something similar.
Yeah. And this is a topic that, as we all are well aware, the pronoun issues, the censorship things, all of the various legislative acts redefining certain aspects of the curriculum and what's okay to teach and what's not okay to teach, all of this stuff is everywhere right now, and it's all being heavily litigated. So, I think these things are going to be front and center in our legal system over the next few years. So, and we will cover all of it for you all, folks.
Right. Yeah.
Yeah. So what have we got for homework?
For your homework, like and subscribe to Chalk and Gavel. You can find us wherever you find your podcasts. Make sure to check out our upcoming episodes on our website, chalkandgavel.com. Join the conversation on social media. You can follow us at Chalk and Gavel. We'd love to hear from you, love to continue the conversation. If you have thoughts for upcoming episodes or questions about anything we've covered that we didn't address, or just wonderings that you think would be great for us to address on the show, please hit us up. We'd love to hear your comments and feedback.
Okay, so that does it for this episode. Thank you so much for joining us. Can't wait to dig into the next one in 2 weeks. And, stick with us. We've got some really interesting cases coming up. We've got some special guests who will be joining us in some future episodes. So stick around. I'm Jamie Cudlitz.
I'm Chris Thomas.
We'll see you in 2 weeks. We're going to talk about a case that has to do with searching a student's cell phone. So please join us. See you then.
So the kids are all